Good morning. The court calls N. Ray E.B. and welcomes attorneys Miller and Thompson to the virtual oral arguments today. This is the third day in the court's 200th year history that we've had the opportunity to host virtual oral arguments. So we're delighted to have you as well as those who join us. Mr. Miller? You are muted, Mr. Miller.
Thank you. Justices, and my friend Jane Thompson, thank you very much for the privilege and the opportunity to speak to the court today and have a conversation with regard to my client, Mr. Hart, and his continuing effort to reunify and to bring his child into his family as a full member. As your honors know, Mr. Hart, since 2016, has been pursuing Ella to be a full-fledged member of his family, sometimes very well, sometimes not as perfectly as some might do. But in any event, making the effort and doing things that showed his continuing interest. And not only Mr. Hart, who is with us on YouTube, I believe, today, but also his extended family in California, his sister. From the record, the court knows that they themselves were foster children, that his sister married the son of Mr. Hart's foster mother. And they have been close for a lot of years. Mr. Hart, as the court knows from the record, is the father of 4 children, Ella being one, and 3 other children by a different mother. And Ella, born in February of 2016, was a surprise. Mr. Hart didn't know about her birth. He had a relationship with the mother, and the mother at the time of the birth, and I'll simply ask the court to read social worker Morgan's statement as to why the child was relinquished at birth by the mother, who was there with her then boyfriend, and made the decision to give up her child. That was done without Mr. Hart's knowledge or participation, and he was contacted in March of 2016 by the Department of Social Services, to whom Ella had been relinquished. And at that time, based upon the history and the record in this case, he was excited to be a father. He voluntarily took a paternity test. Mother had been at the hospital with someone else, and so paternity, of course, was at issue with social services. He voluntarily took that at his first meeting with social services, and he voluntarily signed an agreement with social services in order to obtain the custody of his child. He did that believing that it was a fairly perfunctory matter. He was the father, he wanted his child, and he simply had to have a suitable or a safe home for the child, and perhaps learn a few things about how to take care of an infant. He had a sister living in California who had 5 children, the first cousins of Ella. He also had 3 other children, ages at that time, 3, 5, and 7, with whom he'd had some experience. And he cooperated with the department immediately and submitted to evaluations at the Genesis Center, and attended classes as well. And his first visit that he was allowed to have by the Department of Social Services was in May of 2016. And he showed himself to be a new parent, unfamiliar to some extent with an infant, but he was there and he was excited. And the record the Department of Social Services record reflects that fact. And from May of 2016 until December of 2016, he participated in every way that a parent could participate, with the exception of complying with invalid and void obligations, barriers to his having custody of his child. He initially had an evaluation that recommended additional substance abuse assessments and classes, of which he took 6 hours of the 20 that were recommended. He took a domestic violence assessment that recommended he attend a batterer's intervention program. And I'm sorry, I've lost video at my end. I hope you can still hear me. And he also was recommended for mental health or individual counseling sessions. He decided, rightly or wrongly, that he didn't need what they required of him. He took 2 drug tests or screens that were negative, one in May of 2016, another in August of 2016. He visited with his child throughout that period of time. And the foster parents described in the record a good co-parenting relationship with Mr. Hart. He was appropriate at all times in his visitations with the child. And throughout December 2016, he appeared at every of these court proceedings. Now, it is undisputed that all of the underlying proceedings that the juvenile court had were without authority. There was no subject matter jurisdiction. That is the concession by the department, and it is also the ruling of the Court of Appeals in this case. There was never a petition filed. And the question that has been asked is, why was there never an in-home services agreement, as is done when petitions are not filed? There never was a petition filed.
Mr. Miller, I don't think that the invalidity of the original permanency planning orders is disputed. I think the question, it looks to me like we've got before us, is in essence, what do we do now? The Court of Appeals, at least as I understood the analytical approach that all 3 members of the court seemed to agree on, they didn't agree on how to apply it, but I think they agreed on a rubric for deciding it, was to say, in effect, that those findings that weren't impermissibly tainted by the results of these invalid permanency planning orders could still be considered, and at least in the majority's opinion, there was sufficient evidence, sufficient findings to support abandonment. Judge Hampson didn't agree with that. Do you disagree with that overall framework for analyzing this case?
No, sir, I think that's exactly the framework for analysis. The purpose of my comments were to show what happened here, and that this father, from the beginning, wanted his child and did not abandon his child, and the analysis of abandonment was incorrect. But it also arose out of the invalid proceedings.
How do we, the question I've been struggling with in trying to work on this case myself is, how do we figure out which findings are and are not fatally tainted by the invalid permanency planning orders?
The difficulty, and I recognize that difficulty, and I think the Court of Appeals did not do it appropriately. I think the thumb was on this father's head from the beginning to the end. And the abandonment issues, if you look at what the Court of Appeals seized upon, the 6 items that they talked about, all of them had a relationship to what had occurred and what was happening during an invalid judicial process in which he was being directed and required to do certain things. And my proposal is that invalidity of the underlying proceeding invalidates the entirety of the termination proceeding and the grounds of that proceeding, because but for that, there never would have been any termination proceeding at all.
I went through and tried to make, look at the list of what they considered and what they didn't consider, at least in the majority opinion. The first one was the father's statement he was going to let the sister handle it. Now, how is that? The majority obviously didn't feel that that statement was tainted by the original invalid permanency planning orders. Why, in your opinion, was that determination in error?
If the court looks at the totality of the testimony, it is apparent that the father's relationship, the father's concerns with the department and with the foster parents who were foster to adopt parents was not to reunify with him. And he decided, and frankly, I think there's a typographical error, and I think the Court of Appeals is wrong when it said 2016. I think it was actually December 2017, which is within the 6-month period of time. But he had decided that he was going to move to California, that his sister was going to get placement of this child because the interstate compact placement was going to occur, and that he was going to reunite in more favorable setting among more favorable people than with the Department of Social Services. And his statement that I'm going to let my sister handle it in December of 2017 was with the knowledge, and there are two of these invalid orders that said, we expect this ICPC to come back in January of 2018. We'll have it then, we'll have it before the January 25th hearing. So he's going to be in California to receive his child at his sister's house where he was living with his 3 children and with her 5 children. And there were going to be one happy family, albeit he presumed under the supervision of the California department rather than the department that he was not having a good relationship with.
Is there anything in any of the trial court's findings in the termination order that in your view is tainted by the invalid permanency planning orders?
Because the entire proceeding grows out of the invalid orders, the requirements that he do services, and him not doing them and them holding that against him all the time, and it always coming up. Because the social worker told him on October 25th of 2017, there's no sense in doing these services because the child's going to go with your sister. And if the placement's going to be with your sister, you don't need to do these services here now. And I want to remind the court that there was a very stark break. And it's unfortunate that it occurred when it did, because that break is what gave rise to the 6-month concern about Mr. Hart's behaviors. He, up to December 16th, went to every court hearing, participated, was involved. Up to August the 17th, he was involved, participated, and he had many more visitations. The order, the termination order, is internally inconsistent about those visitations. When it says that he only had a couple, I think it says 3 or 4 between May and June of 2017. In fact, he had 8 between May and August of 2017. I want to read the court the kind of parent that he was, because the court that in this tainted proceeding and the Department of Social Services at record page 32 said, Mr. Hart has been positive and he has bonded well with Ella. He brings appropriate snacks and comes prepared for all visits that he attends. Mr. Hart changes her diaper as needed. He always assures that Emily is clean, as well as everyone else who touches and holds Ella. Mr. Hart's son, Kay, has been to most of the visits, and on June 28, 2017, all of Mr. Hart's children came for the visit. Mr. Hart assures cleanliness, safety, appropriate parenting, and loving care to Emily during the visits. I want to point out that during this 6-month period, I'm sorry, Judge Morgan, I didn't see.
Oh, well, actually, I was just moving my mouse, but I was preparing to ask a question. So thanks for the opening. One thing we have to do as an appellate court, and thank you for the acknowledgement, counsel, is that we have to look at the trial court order, and in doing that, we've got to make some determinations as to the viability of the trial court's order. And as Justice Irvin raised, there was a finding of fact that the respondent father, your client, said that he was just going to allow his sister to handle the situation. You've given us the background as to why he would have thought that way, but that was an unchallenged finding of fact, which comes to us as unchallenged in the trial court's order. Why wouldn't this unchallenged finding lead to a proper conclusion of law that the father willfully abandoned the child if that statement that led to that finding was made outside of the 6 void orders?
The reason that it would not is because I think this court has been very, very clear, as well as the Court of Appeals, that we have to have conduct that is wholly inconsistent with maintaining or reestablishing the custody and the parental relationship. And the reason that does not present enough evidence is simply because you can see that he is deciding, I'm going to reestablish my relationship with Ella in California because she's going to be placed with my sister in the home that I'm going to live in with all of the other children under the supervision of a California Department of Social Services. And so letting his sister handle it, and she had been very active in participating as a relative, a preferred placement under our juvenile code with the child, with the social services department, with the departments in California. And remember, those people in California went to great lengths. They got licensed as foster parents. They sold their home, got another home that because they had a swimming pool that presented problems that the department out there didn't like.
While I respect and understand the assumptions that were being made by the father here and his optimism about that, I do recall that DSS was not recommending the sister as a placement. And I also, again, go back to the fact that as an appellate court, we can't go behind what the trial court found if it's unchallenged on the record and a proper conclusion of law flows from that finding of fact. So despite what your client may have thought, why is it that on paper at least, this finding of fact should not have been found based upon the evidence adduced outside of the 6 permanency planning orders that were void?
That's an interesting finding of fact, Your Honor, because it really is not a finding. It simply says this is what the Department of Social Services says, but the court doesn't find that it's not in the child's best interest to be placed out there. The court is not bound by whatever the department should happen to say with regard to that placement. The court can still make findings and make the placement. At the time all of this is going on, and at the time of those statements that were made, it is a reasonable and an actual and an accurate statement to say that this father had always wanted to go. In fact, the social worker admitted it, and it was in some of the findings in the void orders. This father, and I can't recall if it was in the termination order as well, this father had always intended to move to California with his children. He'd always intended to be out there as a family. And the method of accomplishing his reestablishing his relationship was not an abandonment. It, in fact, was, if I let my sister get this placement, because they won't give me my child. Remember, in May of 2017, this man filed a document with the court that said, give me my child. They didn't have any authority to keep his child from him. Give me my child. May 2017. So if the finding is it was a 2016 statement, in May of 2017, he's saying, give me my child. And if you're not going to give me my child, place my child with the relative that the law says they're supposed to place the child
Well,
with.
and in that regard, isn't it true that this statement that he made is in fact tainted by the fact that he was not his parental rights were not recognized from the beginning? He wouldn't, his sister would not have been, his sister's house would not have had to be approved by as a foster home if he had been allowed to exercise his parental rights and as a father say, I'm going to send my daughter to my sister's house until we can all move out there. That would not be otherwise considered abandonment under law, would it? So isn't even that finding tainted by the improper proceeding here?
Yes, Justice Earls, it clearly is, because during the entire period of time until there was an actual termination order, he still had every constitutional right as a parent. And he had the right to the placement and the relationships and those sorts of things with regard to his child. And if he'd wanted to, he could have sent his other 3 children out there. And I think it's important to remember, as you judge this parent, that during this entire process, he had custody of his other 3 children as a single parent. And at no time did anyone file a petition or seek to take those children away from him because he didn't provide a safe home. He could not deal with the Department of Social Services in any rational manner in his mind. And the only way that he could deal with them, and if you recall, this issue of subject matter jurisdiction wasn't raised until appeal. So everybody was operating under false assumptions back then, in fairness to all of them. But at that time, he clearly had the right to send his child to whatever relationship location he chose as the constitutional parent. And he was never divested.
I want to ask you about what should have happened under your view, given the absence of a filing of a petition. Was DSS, I would imagine, was they had the right to place the child in foster care upon the relinquishment by the mother until his status could be ascertained, correct?
I don't dispute that, Your Honor. Clearly, the Department of Social Services is going to place a child that's relinquished to them with a foster family or some custodian until they locate a relative. The law says they're supposed to locate a relative.
So I understand from the record that your client signed a family services agreement. I guess my first question is, do you contend that it was improper or illegal for DSS to ask him under these circumstances to sign that agreement?
No, sir. I don't think it's illegal by any means. I think that clearly there would be, in the ordinary course of events, a man like Mr. Hart contacted by Department of Social Services is going to cooperate and comply, and he acted reasonably. Do I think that that document governs anything in the case? I do not. I don't
Why
think
is that?
Because it is a document that is simply an understanding between parties. He is the father. He could certainly agree to leave his child with the foster parents or with the Department of Social Services as a constitutional parent, and he was under no obligation to do anything that they asked him to do. It did not mandate him. It is not a contract that grants custody or that does anything that mandates a parent to comply with.
What did he agree to do by virtue of signing the agreement?
At that time, he agreed that he would have an evaluation and that he would comply with that evaluation. He agreed that he would have a safe home. And you'll remember that he did in fact have a safe home at the Tabernacle address, so found and determined by the department, that meaning a home free of physical or emotional abuse or neglect. He agreed that he would stay employed, which he did. He wasn't employed at the same place all the time. He lost employment only as a result of a severe injury that he incurred in February of 17. And he agreed to have supervised visits when his paternity was established. That's what occurred. Now, I want to point out in that agreement, the only indication in that agreement about domestic violence was domestic discord. There was some testimony later about domestic violence or reports or allegations, but over the entirety of this case, there was never any substance abuse. In fact, social worker Morgan said he never saw the father impaired in all the visits that he had with him. No substance abuse issues, no criminal conviction issues, no alcohol issues, no domestic violence issues. And he had been living with another woman for a period of time. He had certainly been around the area for a substantial period of time. Nothing occurred that indicated he had a need for any of those things that he agreed he would do.
But to what extent did his signing the agreement open the door to DSS involvement with him, even in the absence of a petition?
I think anyone and everyone can be involved with the father of a child, and I believe the Department of Social Services comes in with special integrity and credentials for that involvement, and I think he engaged in that involvement. He clearly did not waive anything. He clearly did not grant any rights. I think there is case law cited in the brief with regards to what these services agreements are. They're voluntary understandings between the signatories.
And Mr. Miller, you did not request to reserve time for rebuttal, but if you'd like to, you certainly may.
Your Honor, I cannot see the clock, frankly, on my screen, so I don't know how much time I have left.
You have 3 minutes, 17 seconds left.
I'd like to reserve that time then. Thank you, Your Honor.
All right, thank you, sir. Ms. Thompson?
Ms. Thompson, you're muted. You could unmute yourself, please. There you go.
Ms.
Good
Thompson,
morning.
are you able to see the clock on the screen?
I am. It's in the upper left-hand corner. I am.
I
Thank
just
you.
want to make sure. Okay, thank
Have
you.
you in grid? I think I followed all the instructions. This is, I'm very new at this. I have practiced with my daughters and they have been rolling their eyes, but they've been very patient with me. So I appreciate it. Nothing like adult daughters to, help you with your technical issues. This is certainly an unusual case. Before I retired, I spent 38 years as a child welfare attorney with the North Carolina Attorney General's office, representing the North Carolina Division of Social Services. So I've litigated and handled on appeal a number of juvenile cases. In this situation, the mother relinquished her daughter essentially at birth the next day. Pursuant to Chapter 48, that relinquishment, if not revoked within 7 days, gave DSS legal and physical custody and the authority to place the child with a prospective adoptive parent. Obviously, it doesn't clear the other parent. That still has to be dealt with. But it did give them the authority to place, and that is what they did. They, of course, immediately asked mother who the dad is. She came forward with that name. They contacted him, and really, I think in fairly short order, he came in, he took a paternity test. It came back in about a month or so, and then he did have his first visit. With Ella. In these situations, he, by his own admission, in March of 2016, after he had been contacted, and on the same day he took a paternity test, so we weren't sure at that point he was the father, he came forward and he said, I do have a sister in California, but I don't want her considered. I want the child to stay here. and let me work to getting her. No, I do not have a house set up for a newborn. I have 3 other children, but they live with their mother, which is at that time what they did. So his 24/7 parenting ability was up in the air. Certainly his ability to deal with a newborn was unknown. Yes, I've had drug issues in the past. Yes, there are CPS issues where I was named as a domestic violence perpetrator. So these were no, I had a terrible home life. My mother beat me. She abused me. She treated me terribly. I would never want my child to live with her. So these were issues presented to DSS, who had custody of the child, and their response at the time was to offer him the family services agreement, which is a way that DSS works with families outside of the court process. No, of course it does not pass any of his custody to DSS. DSS already had custody. It is a voluntary process. It's an out-of-home agreement. That is, the child isn't with you. These are things that can happen to have the child be back with you. He agreed to assessments for DV and substance abuse. He got the assessments. He did not follow the recommendations. He never entered the batterer's intervention program.
Ms. Thompson, hypothetically, what would have happened had, once paternity had been established, the father said, I'm not going to do this stuff, give me the child?
Right.
Short of filing a petition at that point, which we know didn't happen, would DSS have had any right to do anything other than deliver the child to the father?
No, Your Honor. And that is where this case diverges. That is, when they find parents who appear to be 100%, appropriate, 100% probably isn't an accurate statement, then in fact, there are ways under Chapter 48 to rescind the mother's relinquishment. She could do.
But hypothetically, again, I'm trying to deal hypothetically with the situation where we have the father that we have.
Right. They would need to file a petition.
And did not.
And they did not. But my point is, they did not. That's absolutely correct. And I don't know why they did not. They already had custody. So instead, they filed a motion requesting a review of that custody and, where are we going to go going forward? Chapter 48 provides a review of relinquishments, but not, not the same as a petition at all. No one in that courtroom in Rowan County saw, understood, recognized that they were moving with going forward without a petition. My point, simply to your point, is that his own admissions, his signature on that family services agreement would have been plenary evidence as a basis of a dependency or a neglect petition, then followed by an adjudication disposition, and then all the reviews that in fact were held, that I understand are void, would have been held. My point is, this was not a Star Chamber proceeding. This was not an ex parte proceeding. No one was attempting to violate his rights.
And I'm not
understand.
And I haven't understood anything in the record to suggest that Mr. Miller or his client are making that accusation. We are where we are. And I'm just trying to figure out, and as I asked Mr. Miller, I'm going to ask you the same question. Analytically, it appears that what the Court of Appeals did, they didn't agree on how to do it, but I think they agreed on what to do, was to say, in effect, some of the findings in the termination order are tainted in some way by the fact that we have these invalid permanency planning orders and cannot be used to determine whether one or more of the grounds for termination exist. Others are not, and therefore they can be used. And so that the question really before us at this point is, are there sufficient untainted findings to support a conclusion that one or more of the grounds for termination found by the trial court valid? Do you disagree with that as an analytical approach?
No, in fact, they cite to Henry AL, which is remarkably similar. And again, I was, and in fact, the DSS did exactly the same thing. they took a little different. They took non-secure custody of the child. They filed a petition. Then mother relinquished. So they dismissed their petition, but still had 2 years of hearings about what to do about dad. Then filed a termination of parental rights petition. And in that case, the Court of Appeals held, and I would argue correctly, that they filed a petition. That's a brand new proceeding. They, of course, had standing. The court had jurisdiction, and they moved forward. And in that case, the Court of Appeals looked to see, were there any untainted grounds? And they found the support ground in that case.
Right.
In this case, I'm sorry.
I mean, and I mean, again, I don't understand Mr. Miller to be arguing that that approach is invalid. I think his argument appears to be essentially all of these findings were in fact tainted by the impermissible permanency planning orders and should therefore not be considered. Question I ask him is the one I want to ask you now. How do we tell which of these findings are tainted and which are not?
Well, I think the first thing to consider when you're looking at the termination of parental rights order is that this is not a situation where the court took judicial notice of the void orders. In fact, they had 4 days of testimony. They had live witnesses who testified to the things that dad did do and didn't do. And specifically, they testified to his contact with and his visits with and his apparent commitment to his child. And I would really like to take just a few minutes to talk about that abandonment ground, because I do believe that the discussion by the appellant was not really focused on that 6-month period that the court had to deal with. And that was
before you do that, let me ask you one other thing. It appears, if I'm reading the record correctly, it appears in essence that in these permanency planning orders, the trial court did in fact order Mr. Hart to do various things that were required by the Family Services Agreement. Assuming that that is correct, is it your contention that this court should consider evidence of his non-compliance with various provisions of those family service agreements in determining whether any of the 3 grounds that the trial court found for termination exist?
Your Honor, I believe that the Family Services Agreement was voluntarily entered into by the father. He took upon himself the responsibility to meet those requirements. You're right, those requirements were then mirrored in the orders that came from the orders of the court from the void hearings. But my point is at the TPR. So we have the Family Services Agreement. We're going to get these assessments and follow these recommendations. He got the assessments. He didn't follow the recommendations. Then you have the orders. Then you have the termination of parental rights hearing at which new testimony comes in about what the father did under the Family Services Agreement. And I think you can simply take out the 6 orders, excise them, and move over. Although I would argue that of all the grounds, the strongest one is the abandonment ground. And because it does have it is basically about what dad was doing to try to continue to have a relationship with his child. And that relevant period, I'm sorry, I missed something. Yes.
I have a question.
I'm so sorry, I'm trying to catch this.
We're all getting used to this. I just had a question about, I'm looking at the termination of parental rights order and trying to engage in the same analysis that Justice Irvin has asked you about, which is how do we determine whether the grounds, the abandonment grounds in particular, were untainted by the orders and the prior proceedings that weren't based on a petition. The question I have is, in consideration of the ultimate termination of parental rights, the adjudication and the disposition, did the trial court consider all of the various assessment records and documents and court reports and all that sort of thing all the documentary evidence?
I think that as I read the transcript, I believe that the DSS attorney did go through with some of the social workers, what happened at this hearing and what court report did you make and what was your recommendation? Yes, I mean, that absolutely would be part of any termination. And since no one thought any of those orders were void, yes, that did come in.
Well, my concern is that in one of the earlier orders in the permanency planning process, the court ordered the father to agree to release all of these various records that might not otherwise be released to the other parties. And if that's how the DSS and the court happened to gain access to all of these records that were then submitted in evidence, how do we untangle that if that release was part of the tainted process, because the court didn't have the authority to order it?
And obviously, that's an excellent question. I'm almost positive that those releases were agreed to in the family services agreement that was prior to any court involvement. I would have to check that, but I'm almost positive.
There's at least one or two places in the earlier orders where the court specifically orders him to sign a release.
Okay. And maybe so that means he hadn't done it. I'm sorry. I'm
just not sure how to untangle that. Can you help us with that?
I mean, I understand that. Again, I believe that at that point they were assuming that he either had or was going to sign releases he had agreed to sign under the family services agreement. But remember, they also had the actual testimony of the woman from Genesis. So not just the document, but she was there saying, this is what we found, this is what we asked for, this is what he didn't participate in. He was diagnosed with cannabis disorder severe. He posted pictures of apparent marijuana use on his Facebook. His daughter was born with severe respiratory impairments, triggered by smoke, humidity, pollen. She has had at least one visit that saved her life to the ER. She certainly cannot be in that kind of environment. So that was certainly not documentary evidence that was based on any release that was court ordered. So I do think the Genesis, I'm sorry.
Well, I hate to interrupt you, but I do want to understand, first of all, if the family services agreement was voluntary on his part and there had been no findings of any, abuse, neglect, dependency with regard to this child and his parenting, didn't he, if it's voluntary on his part, and I understand if he decided not to comply with it, that in itself, based on other circumstances, could be grounds to begin a petition. But if it's voluntary, doesn't he have the right to say, originally I voluntarily entered into this, but now I believe I'm able to parent this child and I would like to have custody of my child. Doesn't he have the right to do that under a voluntary agreement?
He does. He does have the right to do that, which would put the ball in DSS's court to go into court. And again, they went into court, but they didn't file a petition.
So then turning to the termination proceeding and the contention that the evidence here is sufficient to support a finding, the evidence not tainted or somehow a product of the void hearings and the void court orders. The dissent in this case cites INRI SRG for the standard for what a willful abandonment requires, and says that particularly a judicial determination that a parent willfully abandoned her child, particularly when we are considering a relatively short 6-month period, needs to show more than a failure of the parent to live up to her obligations as a parent in appropriate fashion. The findings must clearly show that the parent's actions are wholly inconsistent with the desire to maintain custody of the child. And I'm just struggling to understand how this father's plan to move to California establish a household with his other children and his sister in that 6-month period is evidence that is wholly inconsistent with his desire to maintain custody.
The period we're talking about is October 17 to April of 18. That's the 6-month period. During this period of time, in his answer to the termination, the father admits he had no visits or contact with his daughter for that 6-month period. No visits, no contact. Now, before that period of time, we can also consider it for his intent and etc. Yes, he had some visits. He then had a 5-month period where he had no visits. Then they started and he had a 4-month period where he had some visits. And then basically it fell off a cliff. He did not see his daughter. He did not contact his daughter. He did not send her a birthday present. He did not send her a Christmas present. So what other contact did he have during that 6-month period? He had one home visit in October of 17, just into the period. He was in Lexington. And the social worker, that's when actually he said, I don't want to do any other services. I'm turning this over to my sister, but I do want to visit. This was a different county. The social worker had to try to set up visits in that county, then contacted him because he needed the father to okay some dates. He never heard back from the father. So that was one contact with the social worker in October, one in December when he called and did not ask about his daughter. He asked about the upcoming court hearing. Then he left. He left a general Facebook message of all things a few days before, which the social worker had no idea was there. He did not mention he was going to California in December. The social worker had no idea, and he refused, and this is a finding, to give his address. In fact, as a matter of fact, social services has never heard from him since the termination of parental rights action. So in that 6-month period, he basically just forwent all of his obligations to this child. Now, I understand that he wanted the child to be with his sister. When he left, he hoped this ICPC report would come in soon. He hoped it would be favorable, and he hoped a DSS would place. He could not rely on any of those things. I have a very long history with ICPC, and as you can imagine, when you were talking about another state, it took 6 months before we got anything, an additional 6 months before we got anything from California. And when the child is out there, you have to rely on monitoring from that state. Do they stay there? Does the father have access to the child? He's living with them. Is it appropriate? Is he still smoking marijuana? I mean, everything becomes much more difficult. And even I point out in my brief the case of Invalid DEM, where the abandonment ground was used, and the mother said, well, that's not fair. My the grandparents tried to terminate my rights. It was on appeal. While it was on appeal, that's part of the 6-month period. And the court said, you still have your parental rights. You still have an obligation to have a relationship with your child. This man made no effort for that 6-month period, replicated in part earlier, to have a relationship with his child. I would point out that the assault that he suffered was far before the applicable 6-month period. So,
I think one of Mr. Miller's really principal arguments is that there's something just fundamentally, viscerally unfair about saying that the parent willfully abandoned the child when his access to the child was significantly restricted due to improper government action.
and I understand that position, but again, he cites a number of cases where the father's incarcerated, or in fact, visits were somehow actually curtailed. Remember, this started with a father who admitted he was not ready to parent his child. He did not come in saying, here, I've got this, let's go. He came in saying, wow, I'm a father. Nope, never handled a newborn before. I have my other 3 children, but I've never actually 24/7 parented them, which he later did. So his visits, his access to his child was actually very broad. He was given the number of the foster parents. He was given the opportunity to call. He claims he called over Christmas during that 6-month period. There's a finding of fact in the court order that he did not. The foster parents said they did not hear from him for 6 months. He had many, many opportunities to contact and be a part of this child's life and simply chose not to.
Following up on Justice Earle's question, if he's admittedly not contacting the child directly, but he's taking steps behind the scenes to ensure placement with a relative, in this case, a sister in California, does that count for the abandonment analysis for the 6-month period?
Well, in my opinion, he's not having, I don't understand how as a parent, you simply pass off your obligations to the relative in California, especially when you have no necessarily.
But I'm asking you a different question. I'm asking you, are we allowed to consider those types of steps in determining whether or not he deliberately just ignored the child during the 6-month period? Does that count at all?
Oh, I can't argue that it doesn't count. I think, however, when you look at everything else that he did, he basically stepped out of his child's life completely, even before that situation, even before he left in December. He stepped out of his child's life. Yes, I think it can be considered, as can be the fact that he met once with the social worker and then didn't follow up with any visits, as can the fact that he made one call and didn't ask about his daughter.
Well, I do want to be clear about another thing. The fact that the process for approving the family in California took so long includes the fact that paperwork was lost in Raleigh and had to be sent again. Those things aren't his fault, right? The fact that it took so long for his sister's home to be approved, that was not his fault.
That's correct. They sent the paperwork in as early as April of 17. He was looking to his sister, and they sent the paperwork. Apparently 2 months went by or a month went by. They followed up. The paperwork had been lost. They resubmitted. So there were 2 months there where it was. Once it gets out to California under the ICPC and applicable federal law, they should have had a response in 60 days or an explanation of why they didn't. They simply didn't. This is absolutely one of the problems with the ICPC. There's testimony that they followed through with California. Please let us know, please let us know. Part of it was the fact that she did have a swimming pool, which is obviously a high risk to children. Part of it was that she was gone for a camping trip and wasn't able to be in touch with them for 2 or 3 weeks. Something about a dog came up. So there were some problems on her end and on DSS's end in California.
But eventually she moved her house without a swimming pool that was approved out in California.
Yes.
And you mentioned that he admitted he was not immediately ready to parent a child at the point in time in which he first learns that in fact he has a child. And is that really all that surprise? Most people have 9 months usually, but suddenly being at that point, he was immediately ready to establish paternity. But is that really a huge problem that at the same time he learns he's a father, he's saying, I need a little bit of chance to make the right arrangements?
I think that, on the continuum, I don't think it is, but that was not the only discussion they had. He, in fact, had 3 children that he had never 24/7 parented, and that there had been 3 CPS reports on. And his home was not set up for a newborn, and he admitted drug issues, and they were concerned about domestic violence. So the fact that, oops, I'm a dad, I need to get a crib was not the lead issue.
Right, but in terms of, if we're looking at abandonment and in terms of what indications there are that I thought you were suggesting that the fact that he admitted he was not ready to parent a child when he learned he had the child was a factor we should take into account in assessing.
No, not about abandonment. No, I'm sorry. I didn't mean to say that. My concern is simply that they went out of their, he had numerous and significant opportunities to be a part of his child's life. And I just think when you look at the trial court's order during that 6-month period, he simply did not step up to that plate. And as I said, in the answer, it's not admitted that it's willful, but it's admitted that he had no contact with his child for 6 months. Well, if it's not willful, then why did it happen?
But at the same time,
was it during that time,
at the
etc.
same time, we really have no way of knowing what steps he would have taken to become involved with his daughter's life, but for the improper DSS involvement, right?
Well, no, we do not, Your Honor. I certainly assume if someone had said at the first hearing, okay, why are we here on a motion? This is a motion. Why are we here on a motion? We can't go forward on a motion. In fact, there's one point where the guardian ad litem attorney asked the social worker, so he consented to dependency back in April of 2016, and then he goes, oh no, I'm sorry, I withdraw that question. So if someone had stepped up, it was not as if there would have not been a court proceeding. There would have then been a correct court proceeding. People wouldn't have said, oh, we can't be here on a motion, let's give dad his child. DSS would have filed a petition.
If hypothetically we disagree with you on remand, what's going to happen?
On remand, it depends on what this court says. If you believe that there are no grounds that can be found apart from those orders, then it would be a situation where the case would have to start over.
So there would be no remand. We would simply be reversing the court's order.
I think it depends on what you say about what orders, what findings you believe are accurate, or perhaps there's evidence to support other findings that weren't made. I can't answer that question.
Do you contend that there was sufficient evidence to support a finding of either neglect or failure to make progress?
I have those arguments in my brief, and I will point you to them. I understand that those really get a lot more into the weeds of the findings in those void court orders.
The reason I asked that question is the Court of Appeals didn't rule on either of those two grounds. I know your time's about up.
No, they didn't. I certainly think the neglect ground has strength, again, in the relating back to that family services agreement. So yes, I argue that in my brief, and I certainly would point you to that. I do believe, as they did, that the abandonment ground is the strongest. I see my time is up. I really appreciate this opportunity. Thank you so much.
Thank you, Ms. Thompson. Mr. Ewing, Mr. Miller, a rebuttal.
Oh, you're on mute.
Yeah. Mr. Miller, you're on mute.
I'm sorry, I'm learning. Thank you, Chief Justice. I want to point out on the abandonment ground, the Court of Appeals looked far beyond 6 months. And that's what the appellee has done in this case. They've tried to limit it to a 6-month view, and they've forgotten everything else that's occurred in the case. If we look at the prior decisions that are cited in the Court of Appeals opinion, you have periods of time that are 4 years, 10 years, 5 years, 11 years of abandonment, behavior, and conduct by a parent. In this case, this man went to a child and family team meeting in August of 2017, visited with his child in September of 2017. And under the scenario that he saw, and under the documents that are filed by the court that are invalid orders, his ICPC would be returned in January of 2018 at the latest, and it would come in before the next scheduled hearing. The The question is, are there explanations that are inconsistent with a willful intent to abandon? And in this case, clearly there are explanations. This court looks beyond the 6-month period for the purposes of that intent to see what was the intent of the man. Now, he visited before that 6-month period. He visited after that 6-month period. His sister was active in communicating during the 6-month period. September, October, November, she's communicating with DSS about the ICPC. There are documents that show the relationship and the intent of this man beyond just 6 months of not visiting with his child, 3 months of which he's in California expecting his child to be there under the auspices of a different Department of Social Services and regimen. So I asked the court to focus on what he actually did to determine what his intent was. There's a lot of language about drug use. When he was 17, he had a conviction for simple marijuana. There is no evidence of any other use by him. The Facebook pages of 4 other guys, not him, 4 other guys. When you look at the records in the case and you examine it closely, the non-compliance with the agreement, it was a voluntary agreement made in 2016, and in May of 2017, he says, wait a minute, give me my child. If you're not going to give me my child, put my child with my sister. It is not his fault. What occurred in California and North Carolina, under our statute, that relative is the placement for a child. That's what would have happened initially under Ms. Thompson's scenario of if everything had gone appropriately.
Mr. Miller, your
Thank
time.
you so much for the privilege of appearing. It's been a long time.
Thank you, Mr. Miller and Ms. Thompson. Madam Clerk, would you recess us for 15 minutes?
Oh, yes, oh, yes, oh, yes. The Supreme Court of North Carolina will be in recess for 15 minutes. God save the state and this honorable court.
Back.